My name is Natalie Higgins. I'm an attorney with Hughes Lawyers, and we are based in St. Louis, Missouri. Our firm, Hughes Lawyers, represents a number of different types of clients. We have transportation carriers that we represent through all phases of litigation. We also spend a big part of our practice representing employers in labor and employment related matters, whether that's on the consulting side or all the way through litigation. So the litigation process is something that people are intimidated by. So generally speaking, in the employment setting, the first step of litigation is to receive a charge of discrimination from either the state or the federal agency. So in Missouri and Illinois, you have the Illinois Human Rights Department, you have the Missouri Human Rights Commission, or you have the Equal Employment Opportunity Commission. Typically those offices share a workload, and so you'll either be investigated and handled by one or the other as far as those agencies are concerned. When an employer is notified of a charge of discrimination, the first step is to provide basically a response, and that's something that we prepare in our office. It basically responds to the allegations that are contained in the charge. So if, for instance, a claimant alleges that they were discriminated on the basis of their age, their race, their gender, we would provide an explanation as to why whatever action was taken against that employee was taken, and that it was taken for legitimate business reasons which were compliant with the applicable laws. After you file your position statement, there is often sort of a set of interrogatories that the employer will answer. They're usually just general questions about the structure of your business, the number of employees, things of that nature. But again, having a lawyer guide you through that process is absolutely critical. Employers who try to handle a charge of discrimination on their own are at a severe disadvantage, because the employment lawyer like myself is going to have a thorough understanding of the legal arguments that are going to be important to that employer later on if it in fact results in an actual lawsuit being filed. So you can inadvertently lose rights or defenses that you might have otherwise had. For example, if the claimant filed the charge of discrimination past the applicable statute of limitations, I would know that, and you might, as an employer, not necessarily be familiar with what those obligations are from a statutory perspective. Similarly, there are other defenses that you should raise from the outset, so in that very first response to a charge, to make sure that your story as an employer is consistent through the entire process. Juries and judges do not like when you change your story midway through the game. So it's very important that when an employer is facing a charge of discrimination, that they identify exactly what happened, and that it is done in a manner that preserves all of their relevant legal defenses. And so again, that's so important to do from the outset. It's very important to be consistent through the entire litigation phase, and having a good lawyer evaluate the situation and be able to advise you as to what defenses you need to be raising is very important.